for tuning into another episode of Family Case Files. I'm your host, V, and this is part two of Melvin Punch's case. For those of you who are not familiar with Melvin Punch, he is a co-media director of the show, and unfortunately, a victim of the family torts. But even more importantly, he's going to be a future guest co-host, so you guys will be seeing a lot more of him. So we left off with you wanting to tell us about your second son.
Yes. I have a second son, Kion Punch. He's a year and a half years old. When he was born in St. Vincent's Hospital in Worcester, Massachusetts. His mother went into labor at 1:30 in the morning, and they decided to take my son through cesarean section. So he was born healthy, and he was a happy baby. I stayed in the hospital. It was the Thursday he was born, and we stayed there Thursday, Friday, Saturday, Sunday, and Monday. So the hospital staff, on the day we were to sign him out, they came in and they were congratulating us on our birth of my son. And, we were packing up everything and ready to walk out with him. And then DCF stopped us at the door at St. Vincent's Medical Center with two security guards and told us that they were taking custody of my son. Now, it's a practice in Massachusetts that once an individual has a child taken, they're placed on the DCF Central Registry, which automatically lists them as a child abuser. And any time you have a subsequent child after that, DCF feels that they have the right to step in and take your child. That is unfair, unlawful, and unconstitutional. So the DCF worker who said that she was taking him said that the hospital itself was also at fault, because it seems that the hospitals in Massachusetts seem to be of the opinion that if they can have a child taken into custody by DCF, if I'm not mistaken, the hospital worker gets a bonus or some sort of monetary payment for each child that is referred to DCF, and if they're actually taken. I would think that hospitals should be in the business of caring for patients and not having a business of having DCF come into the situation and take someone's child, unless there is a situation of abuse. Now, my son, like I said, we stayed in the hospital. The mother and I, Amy, and myself stayed in the hospital room with my son for 6 full days. The hospital gave us a chart on which they wanted us to list as we changed his diaper. I guess they wanted to know if the color of his feces went from like yellow to green to brown. They wanted to measure that. But since my first son was taken, and there were the hospital, which was Boston Medical Hospital, which did pretty much the same thing as Worcester Medical Center did, intentionally tried to find a reason to call DCF to take my son. They said that they wanted to collect the feces of my son so that they can test it. Then they were also insistent on the mother giving them a urinalysis, because even though the baby was sedate, he was fine just as a normal newborn, because I've raised 2 daughters that both graduated, and I raised them from infancy to adulthood. So I know, pretty much how infants are and how to deal with them. And, so we were doing everything fine. And, the hospital staff, they were saying that, we were perfect in our caring for my son. And then DCF came in and said that I had interfered with the hospital collecting the diaper for testing or something to that effect. And that's why they were taking my son. Now, how does that equate to abuse or neglect? Or how does that give them, DCF, a reason to basically kidnap my child from me after I spent 6 full days with him, caring for him every day and every night? I never left the hospital. And they said because I interfere with it. And the reason they said that was because I called them at about 3 in the morning one morning, 1 in the morning for the diaper collection. And then they waited 2.5 hours because they said that they wanted to actually change the diaper themselves at that point because for whatever reason. And they wanted my son to sit in a soiled diaper for 2.5 hours. And I just thought that that was unacceptable. That would have constituted, in my opinion, abuse and neglect from letting him sit in that soiled diaper for so long. So I changed the diaper myself. And I disposed of it. I just, got rid of it. And they said that I interfered with it by changing the diaper. So that was DCF's allegation against me. And when we went for the fair hearing for my son, they suddenly produced a lab result stating that they had species that they tested, marconium, and that my son was positive for substances. When I took a closer look at what they had, it said baby girl, 6 days old, on the day my son was born. So what it seems that they did was they actually falsified a document, put my son's name on another child's lab result. And then they offered that to me as proof that my son was, tainted with substances, that he had cocaine in his system. And for them to be so intent on taking my son into the system that they would actually fabricate evidence, they even actually said that his mother, I went and got his mother's hospital record, I got my son's hospital record. They said the mother was positive.
Bring that up. There's 2 situations of somebody else's records. 2 in this case. So I don't think someone can mess that up twice. I mean, one time you say it's accidental, but 2 different individuals,
Yes.
2 entire separate things in the same instant, falsified records taken, or someone else's records. There's clear intent. They just do not want you to leave that hospital with your child. Now, exactly. I mean, this expensive thing, Joanne, I've got to ask you, are there other scenarios where the incentives are there? Is someone getting paid to take someone's child? I mean, that's detestable.
Well, the reality of it is, I just have a problem with them taking the child anyway, because in order to take a child, as we talked about in the last show, you have to have a warrant. Somebody has to swear on an affidavit, go before a judge, testify to the judge. There is an immediate reason for taking this child, and none of that was done. So the taking of the child from the very get-go was wrongful. Mr. Owens, you talked about a hearing, but you didn't tell us what the hearing was. Was it a court hearing? Was it a DCFS hearing? What was it? Where were you?
I went for the 72-hour hearing because that's required.
Wait. People don't know what a 72-hour hearing is. So can you explain what the 72-hour hearing is? Does it take place in a court, or does it take place at DCFS?
It takes place in the courtroom. The DCF is obligated to bring their allegations of neglect to a judge in the courthouse, in the family courthouse, within 72 hours to justify the taking of the child.
All right.
I attended that hearing at the court, but I mean, I should have been more knowledgeable of it since I had already been through this process before. But the mistakes I made with my first son, and I went all the way through trial and lost that appeal, and then the appellate court, I lost it. In every state level of the state, in the state of Massachusetts, I lost. I was going with my attorney's suggestion, and he suggested that I not actually testify at that hearing, which was a mistake.
That's
I was under the assumption that if I did not testify, then I could come back with more evidence at a later date
no.
and have the judge make a decision. But I didn't realize that by not testifying, then I would not have a chance to say my piece until the actual trial, which I found out today is scheduled for October of 2019. My son was
There you
taken.
go. At least now we're learning something about your case. One of the problems that we had, and I discussed, have no records, and that is a common problem in these cases where the attorneys
Absolutely.
are appointed from a list from the judges. They're tied into the judges. They aren't really representing. They should have filed a motion right away to dismiss for lack of a warrant. That hasn't been done. That needs to be done. And I hope, since the last show, maybe you got a hold of your attorney and asked him to file a motion to dismiss the case for lack of jurisdiction because there was no warrant. When you send these emails, send them in writing. Don't do it orally, okay? You're instructing your attorney what to do. And if your attorney doesn't do it, the next time you go to court or you can file a motion, fire the attorney, all right?
Yeah.
Find somebody who's good.
Well,
Find somebody who's honest.
and something I'm also hearing a lot is, people say, well, I was going to appear, but I was told I didn't have to, and I got screwed over. And then some people tell me, oh, well, there's a hearing I wasn't even told about. I wasn't, there's some people who were just stopped at the door saying, you are not a party to this case, even though the name, this is on the docket, and bar them from the courts and to make decisions.
Well, you don't have a party to the case, but a lot of people don't understand is the fact that you have to file an appearance. An appearance is a formal document saying your name, your address, your email, your contact information. Until you or your attorney files that document, nobody legally has the right has to serve you. All they have to do is give you a summons. A summons says that you're involved in this case. You may be a party, not a party. You're always going to be what they call an interested party, which means you have standing to file pleadings, to make objections, all that rigmarole. But in order to get to that point, you have to file something that's called an appearance. There may or may not be a fee. If you can't afford the fee, apply for a fee waiver. And in fact, this week I have a really kind of funny story I got involved in. I did put it on my blog, and we were able to record the judge throwing somebody out of court, judge's clerk. So that was kind of interesting. But the reality of it is there are these steps that you have to take. And those attorneys that they appoint for you, you have to look at very closely. Who are they? What are their success rate? Are they going to listen to you and take your instructions? You're actually in charge of your attorney. You hire the attorney, you fire the attorney, even if the state or somebody else is paying for that. So it's up to you to ask the important questions. How many cases like this have you done? Do you have any references? What are you charging the state? Are they charging more or less than other people? Maybe if they're charging more, they're tied in and they're corrupt. And then you want to take a look at the person themselves. Look at their property records. Are they taking money under the table? Property records tell you they're taking money under the table. And we can do a whole show on that, how to spot the corrupt, being bribed judge or attorney that's gotten assigned to you, okay? So you have a lot of steps in all of this, but I'm glad you're still in the court system because that gives us time to go back, look at those records, and file the appropriate documents. Does that make sense?
Yes, it does, ma'am.
Well, hold on. I want to ask though. If for the people that understand that they are party of a case or these sort of things, how can they keep track of it? Because I would be paranoid. Oh, this is going on, and what if they call secret hearings? Can I look at the records? Can I see if something's scheduled? I mean, how would a person?
We can go through that. We can go through the process. If you want to get a copy of your file, you're still at the trial court level. Of course, you go to the clerk of court and ask her for a copy of your file. If you can't afford a copy, You need to find the fee waiver judge in larger jurisdictions like in Cook County. For every court floor, they will have a fee waiver judge for the indigent people, and you go before them, and our fee waivers are called 298 petitions, and you get a fee waiver. Now, the trick to those is always ask for a copy of the file and always ask for a copy of the transcripts, all right?
Yeah.
And, you know, kind of sweet talk them into it. You're not going to be before your regular judge can really be, you know, a dirtball. Okay, you're going to be in front of another judge. They're going to sign to it, and usually they'll be pretty good about it. And then what you're going to do is you can do either online a regular docket check. I know for some of these juvenile cases, they don't have it online, but I would definitely write to the presiding judge and tell them to get it up there and get it online because they're pulling all kinds of crap. And I can see in this case, the crap they're pulling is they're falsifying drug testing results.
Yes.
That's the first thing they're doing. But the second thing is if you look at the drug test itself, you're going to find out they're doing a cheap screening test, which is only for a metabolite of the drugs. And of course, we know that these, quote, metabolites of drugs are often mimicked by other food products. For instance, we know that opioids are mimicked by poppy seeds and other types of things. And then we also know in your case, cocaine and other things are also mimicked by other types of food products. So that's the first objection you're going to be file, and you got to get it on there, and you can't let your attorney say no or get lazy or whatever is. You are given a warrant. There was no emergency. The child was in the hospital. It was being protected, and it was being looked after. There was no excuse for not getting a warrant. All right? The second thing you got going through is the drug test, the mishandling and chain of evidence. They call chain of evidence of a drug test, and you need to file a report on that, look for other parents online that are complaining about it, because they just took down a testing facility in Canada that was operating for 8 years. They were not doing the alcoholism test correctly, and what they were doing is probably intentionally to take away kids, using the alcohol level test for women that didn't color their hair on everybody, and it was an excuse to take kids away, when in fact most women color their hair. They used hair, I do too, okay, and therefore the tests are wrong, and they're suspect, and they just got after them for that. But this is 8 years of losing your kid.
Wow, that's a lot of children were taken based on those
They
false
were
results.
taken on a improper handling of hair follicle samples and test results, reading the wrong test results. At one testing facility in Canada, if you go to my blog and put in, you know, fake drug test, it's going to pop right up, or you can get right on Google. You can find that really quick. Okay.
Really quickly, what's your blog address?
Yes.
www.marygSykes, MARY, is in Grace, Sykes, SYKES.com. I know it's a weird address, but it was the first case I took on that was incredibly, incredibly corrupt. It was in the probate court system, and Mary G. Sykes, unfortunately, was granting that. They took about $300,000 in attorney's fees out of a small estate. She was transferred from nursing home to nursing home, and in the end, they murdered her. Okay? It's a very serious case, and that's the name of the blog. She's actually somebody who was in our neighborhood, and I tried to help her and protect her. And that's why the Illinois ARDC suspended my license for speaking out like cases like that, for telling people their rights, for warning people about probate. Don't go into probate. Never go into probate. They're going to steal all of your money, and in the end, they will kill off your beloved mom, dad, grandma, grandpa. All right? And we have all heard about those cases, and we have to reform the system.
Absolutely.
Yep.
And I'm sorry about your case, and I can see a whole bunch of holes and inconsistencies. One of the things you can do right now is you can make sure your attorney is sending you the transcripts. Every time he goes into court, ask him to order the transcripts, and you want a copy of them. Make sure he's filed your fee waiver petition, so that one day the judge doesn't go, you know, all those transcripts that are $2,000, pay him or I'm not going to let you appeal, which of course is another unconstitutional thing I've heard of. I have heard of parents being told they can't get transcripts. I just heard yesterday a Pennsylvania case. There's a bunch of parents who were told by the judge they could only order a transcript if they got the judge's approval, which is completely unconstitutional, okay? And the judge wanted to review the transcript first and correct it. How much more corruption can you get there? And I told them, get together, get a lawyer, and go file what's called a supervisory petition with the Pennsylvania Supreme Court. Clean up this corruption. Transcripts are public. They're made available to the public. You may be in a juvenile court proceeding, but only you and your wife hold the right to keep it in secret. And I'm urging parents to file a notice with the court. Due to the problems in our troubled system, I want my case to be made public. I want everybody to know about it.
I put in a motion to have my trial heard before a jury. I put in a motion to have a speedy trial done.
See, now these are pro se motions that are not going to go anywhere, and we can't talk over each other. Okay? So you're first, and let's do these step by step. A motion to be heard before a jury, I can tell you it ain't going to fly. All right? If you want to get jury trials, which I'm not really for when they're removing a kid, because it just shouldn't be removing the kid, all right?
Absolutely.
But you have to pass a law. All right, so that's going to be your first step. If you want a jury trial in these cases, you're going to have to get your state legislature together, and you're going to have to pass a law. So that was your demand, and that was a wasted effort. I would say don't go there. All right. So, but the transcripts are important. So you have to get your transcripts. And if you haven't had the final hearing, I guess you could appeal. Maybe your attorney appealed after the removal. There's several steps to these proceedings. One of them you mentioned was a 72-hour hearing. Next step would be some kind of adjudication to remove the kid from reuniting with the parent and put them on the adoption track. And I think at that point you can appeal right there. Okay, that's usually where your first right to appeal is. But the problem with that is, unless you have all your objections on the record, the main objection is DCFS or whatever they are, they never got a warrant. That's got to get in there, because if it's not in the record going up on appeal, you can't bring it up on appeal. All right? Very, very, very important. Gotta get all your objections in. I was going to ask you.
If you recall, I sent you the adoption of Leroy, this right here, which I faxed over to you in a PDF. This was the appeals court decision for my son that was taken. I sent these documents to you, and you told me that you needed to have them scanned. They changed my son's name from Melvin Jr. to Leroy. So I sent you multiple documents on my first case.
Joanne, you speak about the filing and saying that you never got a warrant. When a person does that, what's supposed to happen at that point? Is the parent supposed to get the child right back, or is there no process?
Yeah, if you get the child right back, they should just tell them, hey, judge, there's no warrant. I want the case dismissed. I want my kid back. Yes, that's what they're supposed to do. Now, sometimes that happens, and you can file in federal court at the same time for wrongful child removal. And 42 U.S.C. 1983, deprivation of rights under color of authority. But sometimes, and then you're going to have to get an injunction against them who are harassing you, because sometimes they turn right around and they try to remove the kid. But there have been people who have made it through the process. They've gotten the case before a jury. They've got their $1, $2, $3 million for having these kids removed. And then as soon as the ink was dry on the check, DCFS came after them again.
Yes.
And this time they were successful because they got the warrant. And they checked the right boxes, and they gave the right testimony. So you have to realize, even if you win your federal court case, you got to get the hell out of Dodge, because these people are vindictive, and they come back, and they come back, and they pick on the same people. And it's because they had success, they can pick on them, and they're an easy target. So that's a step way down the road. We haven't even gotten past get all your documents together. Get your transcripts. I'm told that in Pennsylvania, they were stopping people from getting transcripts. And that's a huge problem, because people are actually losing their appeals because this judge, and I don't have his name, I asked the person to write up a story for the blog, This judge was keeping people from getting their transcripts so they can't win the appeals. I'm sure if you read in the appellate court cases, lots of times they say, oh, we'd love to help this person more, but we don't have the transcripts, you know? So very, very important. If you're not in this type of a case, if you're in a regular probate decedent's case, they're not going to have anybody typing up your transcripts. You have to bring your own court reporter, and always bring your own court reporter. Because if you don't have transcripts, you're not going to win on appeal. Document the fact that your attorney is not doing his job, and when they don't do their jobs, you want to file a bar complaint against them and get them removed. You also probably want to do blog posts about it to warn others. Hey, this is not a good attorney. This attorney is causing all kinds of problems for me, and he's lying to me, okay? I've got lots of case examples on that. I had one lady, she hired an attorney. She's in probate. They tried to kick her out of her own house. This is a common story. They tried to kick her out of her own house. And then what happens is the attorney says, no problem, you weren't served, I'm going to get dismissed. She goes to court, and the only thing everybody tells her is she has to sign an agreed order to leave the house in like 3 months. It's insane what happens.
Yeah, they play by their own rules. They absolutely play by their own rules, and they don't follow any state or federal law. DCF has total authority in the state of Massachusetts to go into anyone's home and remove their child. And they also try to take the children mostly from the hospitals. They target low-income people who cannot afford proper legal representation. And they also target people who have had their children taken previously. It is almost their mantra. If one child is taken and the person has another child, they will take every consecutive child until that person either is deceased or they leave the state. Now, I cared for my son for 6 days.
No, but you're talking about people who drill and pump oil wells and wait around to refill again. And, you know, if you tap the resource, you're going to suck it dry. If you got it easy, and it's that victimization thing that they have to re-victimize. That's the MK Ultra mantra. I just want to add that in there. Go ahead.
But they fail to really look out for the best interest of the child. My son left the hospital with an excellent bill of health. I cared for him for 6 full days, and yet the social worker could go into court and perjure herself and say my son was at risk. If he was at risk, then why did they let me care for him for 6 days and 6 nights in the hospital, and the hospital staff can state that he was well taken care of? But because of a pattern of kidnapping his children from his mother, they felt they had a right to take this child also. This is the second son of mine that they've taken. After my first son was taken, that is what placed me on the registry and put me in their bullseye. So that means any child that I have in this state is subject to be taken because of the fact that, as far as DCF is concerned, I am on their central registry as a child abuser. But they're the ones that make that designation, and they do not have any proof of that whatsoever. I am a solid, upstanding citizen. I don't do any crimes. I don't abuse any children. All I wanted to do is be a father and be a father to my sons and raise them to be strong and upstanding young men. Let them have knowledge of my family history and my culture. My father fought in the Korean War, and my uncles have fought in every war. Well, my family members have fought in every war this country has ever had. I myself am a disabled veteran. Worked in the New York City corrections system, and 21 years in the Postal Service here. Own 2 properties, one of which is a residential shelter. And still, I am not fit to raise my 2 sons, even after having raised 2 daughters. They both graduated from 4-year universities and who are doing quite well.
Now, Melvin, this court date you've got coming up in October, what's that for?
This is for custody of my son. They are trying to make a determination if they're going to have my son adopted away from me, which is their intention from the very beginning. That they can change. At first, DCF will set a goal for reunification. Then they'll give you a service plan which entails you going to various services and things of this nature. They had me take a parenting class. Now, that was with Pranay. I've taken this parenting class before with my first son and successfully completed it. It's an 8-week course. But now, Pranay, just to double dip and get me to go to their class again, it's paid for by out of the Social Security Trust Fund. This is our Social Security money that they are using to fund these abductions of children throughout the country. For every child that's taken, the state receives money from the Social Security Trust Fund, which is the federal government reimburses them from the Social Security Trust Fund. These crimes, basically, which are crimes against humanity, have been in full effect since President Clinton enacted the Safe Family Act in 1979, which provided financial incentives for states to place children into the system. There is no incentive for DCF to reunify the family. All the money is paid.
That's absolutely true. That's absolutely true. And I want to talk about this really quick. I know, Joanne, if you know more about this, I think what they call it, Title 4?
Title 4D, yes, sir. Title 4. It needs to repeal it.
Hold on, Melvin. And so we have the Social Security Fund that is supposed to be going to disabled people who need it. Now, with that being attacked, you've got people who should be on disability not getting the amount of money they should be getting to keep them in a impoverished level. That money is being used to snatch children away. And then, Joanne, I know this is the issue with probate court, right? I mean, you've got all these elderly people which are being taken out. So they're really trying to attack that welfare part of this and fund terrorism. Basically, that's what I see. What's your opinion on that?
Well, I don't really think funding terrorism is there. I think what's going on in probate court has been going on for a long, long time. And the reality of it is that we have to put better systems in place for more oversight and not make this a honey pit for lawyers and judges. That has to end. With respect to Title IV funds, I don't know what they're doing with that, but the reality of the situation is they get paid anyway. So the fact that they need to draw in $150 a kid or whatever they're doing, that's absolutely ridiculous. But we need, one of the things that I was going to ask you about, getting back to the court proceeding, which is coming back, is what is the name of your judge? You should be working on removing that judge. If this judge is railroading your case, not letting you talk, he appointed an attorney who appears to be inept or working for the system, get rid of the judge. And we do that by flyers, by protests, and we removed a lot of judges by just getting on their butts and informing the other judges of what they're doing in court. They're removing children. There was nothing wrong with your kid. You're a good parent, disabled vet. You're not a criminal, and yet they're trying to take away your second son. Yes. And they didn't have a warrant in either case. You confront them with the fact there was no warrant, and now you've done one page of information, and you can get that flyer out to all of the judges, put it on their cars, stage protests out in front of the courtroom, do it at 9 o'clock when they walk in, and when they leave in the evening at 5 o'clock. They all have their little formats that they do. They don't work many hours during the day, so they basically work 9 to 9:30 till about 5:30, and they're gone. They're out of there. So it makes it really easy to get to these judges and say, hey, you shouldn't be here. You can't do your job, please leave. And that's in addition to filing your judicial complaints. But you should be filing bar complaints against your attorney, firing them. I know people have fired at least 3 or 4 attorneys in the process, okay? And they had to do that to get their records. DCF records, you can FOIA them. If you don't know what FOIA is, it's FOIA, or Freedom of Information Act. And DCFS has to give you your records. And a lot of these agencies have really stonewalled parents into getting the records, but bring it up with the judge. Say, Your Honor, we can't go any further with this case because I FOIA'd my court records over a month ago, and I don't have them. I need my court records. And I also, you're not required to go through any of these like hamster in a cage routines. We're going to send you to drug testing 10 times a week at the drop of a hat so you lose your job. You don't have to do that. The other thing they tend to do is send you to parenting classes. You can take them online. They're like $20 online, and they're not 8 weeks. They're certified classes that are accepted in every courtroom. So
Yes.
they have a basic level, they have an advanced level, and in fact, one of the things you can do is just wow the court with all the certificates you've gotten, from being able to perform CPR to basic use of a defibrillating device, and you keep on stacking them all up, and you say, hey, the foster parents don't have any of these, you need to return the kid. You
Absolutely.
know, you can also go through, lots of parents have also pulled this one where they go through the foster parent certification training. I like that one too. And
Yeah.
say, him back as his foster parent because you didn't give it back to me before. There's lots of ways you can do this to just drive them right up the wall, and sometimes they do give up. But definitely remove the judge, get to the presiding judge, the chief judge, and remove that judge. They're not supposed to be doing this.
And for everyone that's watching, please, if you end up being on the show, have everyone's name. Seriously. We, again, are judge hunting, okay? We need this down for everyone to see. We'll make our own public records here, okay? Essentially. For my anonymous hackers out there, start doxing. Let's keep track of these people. Let's try to network and get everything going, because if we network our information, we can have our own, monitoring grid on these people, and we'll be able to warn people, get people out of situations before they get there, et cetera, et cetera, et cetera, and do a lot more exposing, which I hope will lead to a lot of prison time for these public servants.
Yes. The judge that presided over the case of my first son is Judge Leary. Now, this judge here, as I stated previously, has had, I think it's his daughter, who died from a drug overdose. So any parent that comes before him with any drugs or alcohol mentioned by DCF in their case, he automatically, regardless of the parent's stature or station in life, would take their child. He has caused more separation of families than infidelity, this Judge Leary. Thank God he's retiring in 3 weeks. So he's gone. But the judge that we have now, she's a lady judge, and she seems to be quite fair. And I have to also say that my attorney is much better than the one I had before. I had Marilyn Matuzik, who she absolutely is incompetent and torpedoed my first case. But the attorney I have now, Attorney Marana, he seems to be quite capable, competent, and he is following my instructions. I am hands-on in this case, and I am telling him exactly what I want and when I want it. But in Massachusetts, you do not have a chance to speak in court until your actual trial. Everything else before that is just proceedings to see if the DCF filed their paperwork right. Once they file their paperwork, they usually will change the goal from reunification to adoption. And once they do that and submit the paperwork into court, that is what opens up the floodgate for federal funding to go into DCF's coffers. And these DCF workers, from what I understand, is DCF, Department of Children and Families in Massachusetts. And they get a bonus, an actual cash bonus for each child which is adopted. So they have to work their behinds off, perjure themselves in court, falsify documentations, all in pursuit of a bonus for every child which is adopted, which is ludicrous. As Joanna said, no child should be taken absent of a criminal charge, criminal complaint, criminal warrant, criminal arrest of a parent for abuse of a child. Bam. The parent's arrested.
No, that's not what I said.
That's how it should be. But they're going to take children based on allegations of abuse. But 6 days in the hospital with my son, and then we're happily walking out with him. The abuse occurred at no point while he was in the hospital. So why, after 6 full days with him, would they feel they have a right to take custody of my son? That is just wrong. They did it because there's a cash incentive for them to do it. Now, what were you saying, Joanne?
I was going to say that you're kind of confusing things. This is not a criminal warrant. it's a warrant to seize property. Remember, in the Fourth Amendment, you have to have a warrant to seize property,
Sure.
which is. I know kids aren't property, and don't say that I said kids were
No,
property.
I understand what you're saying.
But before the courts can take away your children, they have to have a warrant issued by a judge and either live testimony or they have to have an affidavit by a DCFS worker. You need to get a hold of the affidavit and you need to report the DCFS worker. And
Melvin, let her finish, Melvin.
Yes, I got her. Now, I understand now, but I wasn't confusing what she was saying. I'm of the opinion that no child should be taken unless the parent is charged criminally. That is just my opinion, but I understand perfectly what she's saying.
That's my opinion as well. I really believe that that's the way it should be. But as far as the law is concerned, we are at a disadvantage because most of us don't know law. Most of us are just trying to get by. And so when you have the law, the only way to beat these people is to beat them at their own game. It's really a crime. Our public education system is redundant and so a lot of unnecessary, nobody's going to use pre-calculus unless you're going to be a scientist or engineer. So what's done is law. It needs to be taught in school. I think, at least preliminary, how to deal with the public servant, how to deal with the police officer, proper way of dealing with speaking to a police officer, proper way to talk to a judge. There should be like high school classes like this. How to, just basic legal stuff. But we're all supposed to be subject to the law. There's no such thing as being ignorant to the law.
Well, you're supposed to learn about your Bill of Rights and the Constitution and the Emancipation Proclamation, all these basic documents of a democracy. You're supposed to be given a basic concept and understanding of how the courtroom works, even how criminal trials are taught.
I can tell you, first grade, they put on the little cartoon, the little Bill of Rights, and that's all from kindergarten to 12th grade. That's all I've seen of that.
You're right.
Your recourse is the next thing you do. This is standard procedure. You file the motion. You set it for hearing. You ask the judge on that day that was set for hearing to please hear your motion or set it for a briefing schedule with the opposing counsel. All right? Then you ask the judge to make a ruling. Okay? And when the ruling comes down, the case is over, then you file a notice of appeal and you appeal it. Make sure you got a court reporter. Make sure that you're paying attention to what's going on and make sure you get your notice of appeal in on time. Most states, it's 30 days. You cannot miss these deadlines, all right?
I missed the deadline on my first son. They gave me 30 days. I was supposed to file a writ of certiorari for my first son because after the judges, my appeal was denied. Then I had it taken before the appellate review, which is a three-judge panel which reviews the appeals court's decision. So after that, I had an opportunity. My next move was to take it to the federal level to file for a federal appeal, CERCIORI,
No.
in order to take it to the federal level and have it brought before the U.S. Supreme Court. Now, the system was paying for my attorney through the whole time that I was fighting for my son and even for the appeal. They refused to pay for the attorney to file the appeal for the federal level. And when I asked my attorney how much it would cost, he said $10,000. I didn't have the money.
First of all, I have to correct you on procedure.
Okay,
this is
go
the
ahead.
way it works. You have a trial court. You get a final judgment. You don't like the decision. Then you're going to the Court of Appeals, which is a mandatory appellate court. They have to hear every case, no matter what it is. They render a decision. You don't like the decision, you can do something within 21 days generally. So watch that deadline. It's called filing a petition for rehearing. Then if they turn down your petition for rehearing, then you go to your state Supreme Court. All right? You don't go to federal court. That's getting everything confused. All right?
Right.
So then you go, now you're going to be filing a petition for certiorari, and the word certiorari means it's a permissive appeal. They don't have to take every case. They generally take just a small percentage of cases, between 1% and 3% a year. I don't know what they do with the rest of their time, but that's all they take.
State level, right? State level? That's on the state level still?
State levels. Let's not get confused. After the state level, if you meet the criteria, you can file with the U.S. Supreme Court. Generally, it's not worthwhile filing unless you can find some kind of discrepancy between the jurisdictions and how they are handling cases. Otherwise, you're wasting your time filing with the U.S. Supreme Court. They only take certain cases under certain conditions, and you have to take a look at the blogs. There's an excellent Supreme Court blog, and they will talk about it. Generally, the U.S. Supreme Court takes one, maybe two pro se petitions a year. Most of the petitions they take, and this is a problem, they come from the same D.C. or New York law firms, and that's 50% of their cases, and they have the same lawyers doing legal argument. I have no idea how they get away with that. We have no diversity at the Supreme Court, and somebody should be filing some kind of petition there on it, because I think they should be taking half pro se petitions, and they should be taking half representation petitions. And if you don't like pro se people, then you have another Supreme Court, maybe a sub-Supreme Court for all these pro se petitions, because there are people with valid cases. Now, what they need to do is they need to explain to pro se people, like I'm explaining to you, get all your records, get all your transcripts, get all of your DCFF records and all that, and give people time to do that, because right now we've got a problem where people are being denied their transcripts, they're being denied their DCFS records. But I did want to straighten it out. I don't want anybody to walk away from this video thinking you go from the state trial court to the state appellate court and then to the federal court. No, you can file a separate federal court proceeding for damages, which I suggest everybody does.
We've run out of time here. I would like for people to visit Joanne's blog. It's good stuff. Good stuff. It's good enough to be attacked by the courts and have them take away your license. It's really good stuff. Great work. I also have a group page for this show. If you want to be a guest on the show, you have to contact media directors, and they'll get you on and schedule with a lawyer. And I just want to say thank you, Melvin, for coming on to the show. We're going to have to follow your case, honestly, and we'll see how this process goes and see what happens and do the breakdown, because you can't really get to the bottom of anything without a playthrough, a breakdown. And so this has been another episode of Family Case Files. Catch us next week.